This brings me to protective rights, which under Florida law are primarily established through shareholder agreements. This law is powerful. It allows shareholders to create binding agreements that can govern voting, management, dividend policy, and even transfer restrictions. These agreements must be signed by all shareholders to bind the corporation, but Florida law gives you tremendous flexibility to negotiate protective provisions. Common protective rights include veto rights over additional debt, blocking the sale of the company, preventing dilution through new share issuances, and requiring unanimous consent for certain major decisions. I always tell my Florida clients that if you're investing as a minority shareholder and don't negotiate for protective rights in a shareholder agreement under Chapter 607, you're at the mercy of the majority. Now, there's also the issue of preemptive rights. Under the Florida Business Corporation Act, Florida shareholders do not have preemptive rights unless the Articles of Incorporation specifically grant them. This is a critical default rule. Without preemptive rights explicitly stated in your articles, your ownership can be diluted to almost nothing as the company issues new shares. If the articles state that the corporation elects to have preemptive rights, then you get the right to acquire proportional amounts of new shares before they're offered to outsiders. But this must be in the Articles of Incorporation. I've seen Florida founders go from owning 20% of the company to less than 2% after multiple funding rounds